Hello and welcome to the Kanu'S TV, a news channel that keeps you updated on everything going on in the country. Welcome once again, my people. Sit tight as you're about to be updated on what is going on in Nigeria. Note that here at Kanu'S TV, we keep you updated on everything happening in every sector of Nigeria. From politics to religions to academics to business to sports, entertainment, music, movies, we keep you updated on everything going on in each sectors because we want you to be carried along in whatever is going on. So if you are yet to subscribe to the Kanu'S TV, do well to click on the subscribe button now, right there in front of you, and be subscribed. And don't forget to turn on your post notification so that you will be notified whenever we make a post, because when you do, YouTube will immediately automatically notify you that the Kanu'S TV has made a post, and that way you'll be able to follow through with our post for that day. Let's listen to the news headline for today. Court to Nnamdi Kanu, why your case against federal government DSS was dismissed. As we know that in the recent time, Kanu filed a case against DSS for not allowing him have a fair hearing with his lawyers. They did not allow his lawyer enter, but then the case was dismissed, saying that there was no proof that it actually happened. A federal high court in Abuja had dismissed a 1 billion suit filed by Nnamdi Kanu, the detained leader of the proscribed indigenous people of Biafra, against the federal government and Department of State Services. Justice James Omotosho, in a judgment on Monday, offered the reason for the dismissal of the case by the IPOB leader. Omotosho said Kanu failed to provide credible evidence to back the alleged violation of his fundamental right by the DSS and its Director General, Yusuf Bichi. He said, "I have gone through the evidence laid before this court, and there is nothing placed by the applicant Kanu to show that the intended third and fourth respondent, DSS and DG, prevented him from seeing his counsel, or that they prevented the counsel from taking notes, or that they eavesdropped on their conversation. The applicant only said that he believes the fact to be true without any proof of such belief. There are no dates or specified details to when any of this occurred. There is no evidence or any specific information which the third and fourth respondents gleaned from the conversation with the applicants can prove. Perhaps if the applicant was able to pinpoint a particular information he gave his lawyer, which the third and fourth respondent used against him, he should have held his case." The news agency of Nigeria report that the IPOB leader, through his lawyer Aloy Ejimako, has sued the Federal Republic of Nigeria, Attorney General of the Federation, DSS, and its DG as first to fourth respondents, respectively, in the originating summons marked FSC/ABJ/CS/1633/2023, dated and filed December 4, 2023. Kanu prayed for 8 reliefs. He sought a declaration that the respondent act of forcible seizure and photocopying of confidential legal documents pertaining to facilitating the preparation of his defense, which were brought to him at the correspondent detention facility by his lawyer, amounted to denial of his right to be defended by legal practitioners of his own choice. He sought a declaration that the respondent act of preventing his counsel from taking note of details of counsel's professional discussion consultation with the DSS detention was unlawful. He also sought a declaration that the respondent act of preventing his counsel from taking note of details counsel professional consultation with him at DSS detention was unlawful. He further sought a declaration that the respondent act of eavesdropping on his confidential conversation with lawyers amounted to denial of his rights. Among others, Kanu therefore sought an order of injunction restraining and prohibiting respondent from the act of forcible seizure and photocopying of confidential legal documents brought to him at the detention facility by his lawyer. He also sought an order mandating the respondent to jointly and severally pay the sum of 1 billion as damage for the mental, emotional, psychological, and other damages he suffered as a result of his rights breach, among others. But in a counter affidavit dated and filed by the DSS in March 12, the security outfit denied allegation leveled against it. In the application disposed by Yamuji Baiya, a legal department staff, he said 11 paragraphs in Kanu'S affidavit were untrue. He averred that Kanu was in safe and secure custody of the DSS. He is not detained in solitary confinement. According to Bééñ, the applicant Kanu is allowed to access his family members and team of lawyers on his visiting days without any hindrance whatsoever. He averred that Justice Binta Yako of his sister court, who is presiding over Kanu's criminal trial, had always maintained that a visit to him should always be under supervision, as it is the best practice all over the world. Delivering the judgment, Justice Omotosho observed that the DSS and its DG submitted that due to the charge against Kanu, it was necessary for them to check the messages he passes to the visitors in order to check for any survivor messages to his fellow outside. He added also that the trial judge in the criminal trial had ordered them to supervise the visits of the applicant. This court is also mindful of Exhibit SSS1 and SSS2 attached to the further counter affidavit on the third and fourth respondent, which are the records of the visit applicants cancelled to him. The judge equally observed a letter from the DSS to lead the lawyer to Kanu, Aloy Ejimakor, stating that the rights of the counsel to consult with the applicant was unhindered. Also, that communication between the counsel and the applicant will continue to be confidential, personal, and without inference. The court thinks these exhibits show clearly that the allegations made by the applicant have been refuted by the third and fourth respondents. There is no evidence of communication being hindered or intercepted by the third and fourth respondent, or that they were prevented from taking notes when they consulted with the applicant. Omotosho held the IPOB leader cannot rely on bare assertion or make speculation without any proof of the same. Mere assertion without credible proof is insufficient and would not avail the applicant, he said, citing Section 135 of the Evidence Act to back the ruling. According to him, the applicant has failed to establish the breach of his fundamental right to fair hearing by the third and fourth respondent. He declared thus relief cannot be granted. In the final analysis, there is no credible proof of breach of fundamental right to the applicant. Consequently, this application is hereby dismissed. And so it was dismissed because they claimed that Kanu could not give them enough evidence to all his claim, and for that reason, Kanu remains in Kanu's request to sue DSS was in vain. And that is the news for today. Let me know what you think about this news in the comment section. What are your thoughts? What are your observations? Let us know what you think about this news. Your opinion matters to us. We want to know your thought about this news. We want to know what your observations are. We want to know what your opinions are. So please comment below in the comment section your thoughts, your observation, and your opinions about this news. Don't forget that this is the Kanu'S TV, a news channel that keeps you updated on everything going on in Nigeria, in every sector in Nigeria. So if you are yet to subscribe, do well to click on the subscribe button right now, right there, so you can be subscribed to the Kanu'S TV. Don't forget that it is important that you turn on your post notification so that whenever we make a post,